委員，多謝大家出席先。
Members, thank you very much for attending the meeting of the panel on administration of justice and legal services. We've already formed a quorum, so I now call the meeting to order. May I refer you to the agenda of the meeting. Since the last meeting, we received one information paper. It's paper 216-01, which is a copy of the statement made by the Secretary for Justice at the press conference on the 4th of December 2012 that the West Wing of the former central government officers will be allocated for office use by the Department of Justice, as well as law-related non-governmental organizations provided by the administration. Next item on the agenda, items for discussion at the next meeting. They are set out in two papers. Paper 225-01, which is a list of outstanding items for discussion. Yes, Deputy Chairman. Thank you, Madam Chairman. I hope that this panel will recall the last time when this panel discussed NPC's interpretation of the Basic Law was the 27th of February. And that's Article 158(3) of the Basic Law. I hope that the panel will continue to follow up on this and put this item on our agenda. At present, individual cases are sub judice, so I'm not asking members to comment on those cases. That's not our intention. I'd like to discuss Article 158(3) of the Basic Law at the policy level in relation to NPC interpretation of the Basic Law. Mr. Alberto, well, the Secretary for Justice requests the Court of Final Appeal to ask the NPCSC to interpret the Basic Law. This is very important, and this action and decision may have far-reaching implications. I, of course, would want an adjournment debate, but I do not know how the electoral president will rule. Can we discuss with the Department of Justice and arrange a meeting to discuss the issue? I think we can discuss the general principles. We did have similar cases for which NPC interpretation was not sought, and just now the administration changed its position. As for Article 24, I'd like to say that the matters mentioned therein are under the autonomy of Hong Kong and should not be raised with the NPC for interpretation. So I would like to have a special meeting for discussion. Mr. Tam Yu Chung, Madam Chairman, my view is just the opposite. Yesterday, the Secretary for Justice already explained the issue. At this stage, I don't think we should have any more discussion on the matter, because we do not want to influence the CFA. So this is not an opportune time to have a discussion. Even for the interpretation of Article 158(3) of the Basic Law, we should wait till the CFA has made a ruling before we discuss. So at this stage, I do not agree that this panel should discuss what the Secretary for Justice said yesterday. Mr. Liu Kong-Che, Emily Lau, Sid Ho, and Paul Tse would like to speak. 1 minute each, please. And Claudia Mo. Madam Chairman, I oppose the discussion of the principle of interpretation for Article 158(3) of the Basic Law, even if we are to have a general discussion on principles, because some cases are sub judice. I welcome discussions in future on such principles. But before the CFA concludes on the matter, we should not discuss the issue because our discussions will be reported. So we should wait till the CFA completes its proceedings. Next, Ms. Emily Lau. Madam Chairman, we say we're not going to discuss. But this morning over the radio programs, there were heated discussions. I really don't know what's going on. It's just like years ago, we would like to have a discussion on the exchange rate, which was wrongly reported. We respect the CFA, but if we are to discuss till the CFA has passed a ruling, there's no purpose for discussing anymore. We should draw a line somewhere. Every day the radio programs are discussing issue. I think maybe next month we need to discuss the matter on the streets. I hope that the Secretariat can assist us as soon as possible by preparing a paper on the background so that we have something in hand. I really don't know what our members are talking about. S4J was talking, professors were talking, Mrs. Regina Ip in two councils were also talking. Mr. To, procedures and principles must be discussed because that's our responsibility. Of course, when it comes to the details of the cases, we need to exercise some constraints. In fact, Ms. Elsie Leung from the Basic Law Committee said a lot of things. She said that judges were independent, everybody can say anything he or she likes, etc., etc. But then when LegCo members want to discuss something of public interest, we're told not to do so. Why? Well, in a civil society, we are to have discussions anyway. On the 6th of January, the Civic Party will have a seminar to discuss acts and behaviors that impact on our judicial system. And I invite the chairman to attend. Mr. Poze, well, first of all, I agree with Mr. Liao that cases are sub judice. When we encounter a sub judice case which may impact on our discussions, we'll have to be careful. The government is a party to the litigations, and the government can apply to the court to ask the court to consider a number of factors. Eventually, it's for the court to rule. At this stage, if any party, well, not the SJ, I believe, is to disclose some information in advance, I doubt whether it's against the code of practice of barristers. Thirdly, there are discussions in society. But if the S4J asks me, I would advise him not to comment too much. If we are to further expand the discussion, the damage will be enlarged. Ms. Claudia Mo, thank you, Chairman. We are asking for a discussion on the principles. I agree that we should have a special meeting to discuss the matter. But whether or not it's a special meeting, we have to discuss the matter. Because this incident involves a fundamental principle underlying our judicial independence. Members of the public were shocked. The matter had made the headline of newspapers. The media, the newspapers, etc., are already carrying out broad discussions. Well, society is already discussing the issue. We, as the legislature, are asked not to discuss. This is strange. Ms. Emily Lau said that this is strange. This is not just strange, but absurd. It's unacceptable to ask us not to discuss. Mr. James So? And then Dennis Kwok. Madam Chairman, we ask for a meeting to discuss policy matters which may be related to the cases sub judice, or they may not be related to those cases. We just want to discuss under what circumstances will the administration seek interpretation of the basic law from the NPC. So we would like to discuss policy matters. Policy discussions should not affect the judgment of the court. Dr. Kwakaki, Madam Chairman, we all know that after the S4J disclosed the matter, the whole of Hong Kong, not just the judiciary, were concerned about the principles behind the move. Well, this panel is facing a very important issue. If we are not to discuss it, sorry, we have no choice. We have to be accountable to the public. We have to discuss it and discuss it expeditiously. I ask for a special meeting.
So second round now, Mr. Martin Liu, Mr. Dennis Kwok, and Mr. Paul Chair. I'll give 5 more minutes and then we'll wrap up this item. First round, Mr. Albert Ho first. Madam Chair, well, actually, I formally make this request. If this is to be put to a vote, then I am proposing a vote. But I hope that this matter will not be put to a vote because the right to request for a discussion should be respected. I hope that we could accept that. If, Madam Chair, you can't decide in a moment whether this item should be put on the agenda, then we can proceed to voting. But we are just discussing about the principle. We're not discussing who should be eligible to have the right of a vote. So this should not affect the outcome. Mr. Martin Liu. Well, we talk about principles. But even for court cases, they also touch upon principles as well. We have practiced for over 20, 30 years. For major cases, they also involve principles. It's not just confined to us here. Judges in courts also talked about principles. When judges adjudicate cases, they also consider principles. So it's not the case that our discussion will in no way be affecting their decision. Well, some members said that if we wait for the outcome, then it would be too late. And I feel very strange. Does it mean that we want to influence the court's decision? Okay, you will be in the second round. Dennis Kwok, Paul Chair, Sid Ho, and Ms. Emily Lau, and then I'll draw a line here. We should then make a decision on this item. Have you finished? No, I still have one point to make. I hope that the court can base their ruling on the laws and the submissions from the both parties without interference. Mr. Dennis Kwok. Well, just now I heard some strange theories proposed by members. I'd like to clarify this point. Now, for cases that for which interpretation is sought in relation to Article 158, Section 3 of the Basic Law, it's not the case that we cannot discuss the principles. Well, just like the other agenda item on rape and other non-consensual sexual offences, well, there are a lot of ongoing cases involving rape and sexual offences. Does it mean that we cannot discuss this item? We have the responsibility to discuss the policy areas involving Article 158. Section 3. I don't think our discussion will be in any way affecting the judge's ruling. Mr. Paul Chair, if I remember correctly, the panel discussed the implementation of Basic Law Article 158 and the relevant policies. I am not sure why we're having such a frequent discussion on this item. Again, if it's because of the CFA's case, then it may cause people to think that we're trying to influence the court's decision. As a body that monitors the government in the interest of the public, we should exercise our roles duly, and we should be subject to constraints as well. Ms. Sit-ho. I hope that in a moment this matter will not be put to a vote because the quorum is 1/3. We should not adhere to the majority vote rule. So you should not make use of the simple majority to oppress the rights of the minority in raising issues for discussion. And for U.S., they have a cloture motion that requires 2/3 of the, or 3/4 of the whole council to cut short the filibustering. So I hope that Chairman, you would also abide by this principle. Ms. Emily Lau. Well, we may not be the minority. Well, we are the Pan-Democrats, and I respect Mr. Martin Liao as well. Oh, sorry. I got mixed up with his brother's name. Well, I respect him, who also respects justice. But this morning, when I was in a taxi, the taxi driver asked me how the CFA would deal with this matter, and I said that we should have confidence. We're not trying to interfere with the courts, but the point is we should discuss whether the court should be requested to seek interpretation. And everyone is talking about it. Madam Chair, if there is a concern that we might step outside the line, or if you agree that there should be a meeting and then we should set parameters, then I agree. But if you say that there is no meeting at all, then no discussion is allowed, then I think it's outrageous. Well, in fact, for the Zimbabwe incident and the Congo case, during the last term, our panel also held a discussion. In the Congo case, on the conclusion of the case, we had a discussion. For the Zimbabwe case, we had 2 discussions on 2 different decisions of the DOJ. And for this right of abode case, it involves wide public interest, and I think that definitely we can arrange for a time to discuss this issue. But the matter is when. Should it be discussed while the case is in progress or on the conclusion? And the Congo case also sparked a lot of controversies. And after the conclusion of the case, we arranged for a discussion here. We invited not only the representatives of the 2 legal bodies to attend, and other representatives as well. So I think that a discussion is necessary. And for the points raised by Deputy Chairman, I think that our panel of this term would and should discuss this issue. But I think that the case will come to a decision very soon. Well, for our regular meeting, the next meeting will be held in January, and we can discuss with the Secretariat and the Department of Justice and seek their views on it. Because that's the practice during the last term. So I think we have the right to discuss, and we should discuss the issue, but it should be done at the most appropriate time. So having discussed with the Department of Justice, I will be informing members of my final decision when this discussion will be arranged. Just now, I suggest that we follow the practice of the discussion on the Congo case. I don't think the case would be dragged on for very long because last term, it was in September 2011 that the decision was handed down. And then in 2012, in the beginning of 2012, we discussed the Congo case. Madam Chair, in fact, we don't agree with you. Well, you said you would be discussing with the administration and the DOJ, but definitely you need to involve the deputy chairman and the secretariat and the legal advice as well. And you should report back to us. We do not accept you having a discussion by yourself and then informing us afterwards. Now, that's not our original suggestion. You haven't heard our suggestion. No, I've heard your suggestion. But following the practice last term, I think that it's more appropriate to follow the practice during the last term when we had a discussion on the Congo case, and that is we should have a discussion after the case has concluded. Well, our request is very clear. We want the discussion as soon as possible. You should discuss with the DOJ as soon as possible. Maybe they don't see any problem at all, Mr. Ho. Madam Chair, do you recall that in 2009 there was a case involving someone who's 18 years old, and then the disabled school children could not receive schooling after they reached the age of 18. And at that time, the case was also in progress. And still, we were able to discuss the principles and the normal procedures in this area. I recall I also attended the education panel's meeting on the day in question. But you see, we have very diverse views here. That's why, Madam Chair, I told you, even for filibustering, in order to halt it, you need the 2/3 or 3/4 vote. Well, just now I've already made the decision, and that is when the case has concluded, we will arrange for a time to discuss the item as soon as possible. I move a motion and ask for a discussion as soon as possible. I second the motion. Okay, let's put this to a vote. Mr. Albert Ho proposes, please ring the bell. I claim division. Mr. Albert Ho proposes to call for a meeting as soon as possible, seconded by Ms. Emily Lau. Mr. Paul Chair. Thank you, Madam Chair, for allowing me to speak. Well, this panel is getting more and more disorderly. People can just speak from their seat without raising their hand. And whether the remarks are accepted by you, Madam Chair, I think that the Ms. Emily Lau's conduct is not acceptable. Well, you should not ask the Secretariat to monitor, Chairman. All right, I'll put this motion to a vote, Mr. Paul Chair. If you have attended our meetings before, Madam Chair, right, you should teach him. He doesn't know the rules. Mr. Paul Chair, I think that we should end our discussion here. I did make a request, Madam Chair. I hope that you would not be afraid of the ferocious. Well, those who speak loud would be able to finish the second half of their speech. Well, I don't think in principle we should discuss the item, but if we are really having a discussion on it, I ask for the information papers, including the justifications put forward by DOJ in asking the CFA to seek interpretation from the MPCSC, because I believe that some media have already got hold of the relevant papers using unknown means, and we should have these documents as soon as possible. Well, this is normal practice, Mr. Paul Chair, that when we have a discussion, we invite the DOJ representatives to come as well. During the last term, I also took part in the discussion. Okay, a member has claimed a division, so the division bell will be rung for 5 minutes. The motion is, according to Mr. Albert Ho, Mr. Albert Ho urges the panel to hold a discussion on Article 158 as soon as possible. The seconder is Ms. Emily Lau. Madam Chair, thank you for making things clear on the procedural matters. If your camp is not clear about it, please give them a lecture outside the meeting so as to avoid this embarrassing situation. That let's not waste time. We think that this should be discussed. And that's the case when we have chairman and deputy chairman of a panel. So, Chairman, thank you for reminding your colleagues. Please continue to do that. I was also a deputy chairman. Okay, I think I will stop the discussion here. Well, I need to make this point. Ms. Emily Lau likes to adopt a double standard. What standard? I have been chairman of the FC for 7 years. Well, Madam Chair, are you ringing the bell? Madam Chair, I don't hear the bell ringing. They can't locate the bell. How come? Outrageous. Ask the Secretariat to look for the bell. Because if we don't have the bell, we need to do a search on every floor to locate members. How come the bell cannot be found? Yes, we have a mechanism. If the bell is not functioning properly, then staff members will have to go on each and every floor and knock on the doors to look for members. Well, this is happening to this new annex.
係得未？得。咁啊，開始響鐘啦。
Please start to ring the bell.
因為佢哋坐啲位係舉手嘅啫 ，show of hands。
得，唔緊要啦，唔緊要啦，嚇。有 pen 可以記嘅，冇問題。
係啊，但係我哋要寫低咯，因為佢嗰個位係冇得 record 低嘅。
得，佢 call 佢嚟投票啊嘛，你有個 procedure。
係啊。
咪陣間最後係舉手㗎，但係
We'll take a vote by show of hands, but we still have ring the division bell for 5 minutes.
有啊，響緊啊。唔緊要，嗱，你可以撳鐘咧，你係要俾個 procedure 佢哋翻嚟，撳完鐘之後舉手。5分鐘。 舉咗佢哋反對再舉贊成得㗎啦。反對先啦。有時即刻舉手嘅話，上次我哋都係㗎，唔緊要。我頭先重複咗一次。咁咧就夠鐘啦。咁首先呢，就係
Time's up. Those in favor of the motion, please raise their hands. We have to count the number of votes because there's no button to press. Well, the clerk can read out the name, then we can put down our hands. Kenneth Ra, Chan Carlock, Dennis Kwok, Claudia Mo, Sid Ho, Emily Lau, James Cho, Long Kwok Hong, Kwok Kaki, Albert Ho, Mok Nai Kwong. Those against, please raise their hands. I'll read out again. In opposition, Mr. Tang Ka-piu, Elizabeth Kwok, Chair Wai Chun, Yu Si Wing, Ma Fong Kwok, Martin Liu, Ng Leung Sing, Alice Mak, Tam Yu Chong, Chang Lai Wan, Paul Tse, Chung Kok Pan, Chan Kim Po, Ho Chun Yin. It should be 13 to 12. Please check. Abstentions? Any abstentions? We check again. We've checked the votes. 12 for, 14 against, no abstention. The motion is negatived. So I think I will maintain my suggestion just now. That is, upon the completion of the case by the court, we'll put an item on our agenda and invite the S4J to participate. Our next meeting will be held on the 22nd of January at 4:30 p.m. And next time, we'll first discuss the report on mediation. The S4J will report on the subcommittee on mediation ordinance commencement notice. And then our next item for discussion at the next meeting will be the proposed creation of a supernumerary post of Deputy Principal Government Counsel in the Civil Division of the Department of Justice to assist the SJ to promote and facilitate the use of mediation in Hong Kong. In particular, the Committee on the Ordinance invite the panel to the Subcommittee on Mediation Ordinance Commencement Notice noted that the future operation of the Hong Kong Mediation Accreditation Association Limited and the development of mediation as an alternative means of dispute resolution in Hong Kong are important policy issues, and the subcommittee agreed that the panel should be invited to follow up relevant issues related to the ordinance, including exchanging views with the deputations. I also took part in that discussion, and it was suggested that the item be put on the agenda of this panel for discussion. So we'll issue invitations to related deputations and organizations, and if they are interested, they can come and express their views. And then at our next meeting, the administration will introduce to us the CE's policy address and policy initiatives that are related to this panel. The Secretary for Home Affairs will also attend, and the S4J as well. So I hope members can attend that meeting. And for the Hong Kong Arbitration Center, members will recall that we've issued a thick pile of papers on the rules. Mr. Wong Kwai-hoon, the solicitor, would like to express their views at this meeting. But we did expect additional discussions like the one just now, so we informed them that they should come next year in March or April. I invited him to come in February, but he was otherwise engaged in February, and he would very much want to attend our meeting to express his views. So we'll, as far as possible, arrange a short slot for him. I hope that members will agree to extend the finishing time of the meeting on the 22nd of January to 7 p.m. because the CE would like to discuss his policy address with us, and perhaps members would like to have more time for discussion as well. So I suggest that the finishing time of the next meeting be extended to 7 p.m. Now, members, if you don't have special comments on our next meeting, we'll proceed to the discussion items today. Law Reform Commission's consultation paper on rape and other non-consensual sexual offences. We have a number of papers, paper 225-03, and 3 other papers. Let's invite the representatives of the Law Reform Commission to enter the conference room. Well, this consultation paper was submitted by the LRC in relation to rape and other non-consensual sexual offences. We've invited the LRC and the Law Society to express their views. And then we have another concern group that has submitted a submission to us, and they're concerned about women violence. When we accepted their submission, we no longer had enough time to inform other deputations. So we've accepted their written submission, that is in paper 242-01, that is from the Women Concerned Group, and then another submission from the Law Society, paper 228-01. The Law Society submission is in English only, and the Concerned Group submission is in Chinese only. I'd like members to read the submission of the concerned group as far as possible because they are not represented here to ask questions.
咁發改委有關嘅諮詢文件呢，係喺2001。
The consultation paper has been circulated to all electrical members in October. In the consultation paper, the LRC has made recommendations on, for example, the definition of rape and other non-consensual sexual offences. Now I invite the representatives of the LRC to give us a presentation with the aid of a PowerPoint. Thank you. Representatives of the LRC, Mr. Eric Zhang. Madam Chair, members, I'm happy to be here at the electrical. Today we won't be discussing the weather or the storm because in the capacity of a member of the LRC, we will be briefing members on the consultation paper on rape and other non-consensual sexual offences. I'd like to take some time to take you through the background, followed by our recommendations, and we'll also brief members on the other work done by the LRC. Now, on the comprehensive reviews of the law, we issued altogether 4 consultation papers. This is the first of the 4 consultation papers. This is a consultation paper on rape and other non-consensual sexual offences. And such sexual offences touch upon a very important principle, and that is to promote sexual autonomy and the right to choose to engage in sexual act. So in relation to penetrative assault and non-penetrative assault and non-consensual sex offences, these are covered in the consultation paper. And the subcommittee, throughout the review, would consider the inadequacies in the existing legislation. And some provisions are not gender neutral. And some provisions are based on the sexual orientation of the individual, and these are subject to criticisms. Now, first of all, the subcommittee sets out in this paper very clearly the guiding principles, and they include the clarity of the law, respect for sexual autonomy, the prospective principle, and gender neutrality, and avoidance of distinctions based on sexual orientation. And all our recommendations must adhere to the human rights laws and practices guaranteed by the Basic Law. On the respect for sexual autonomy, this is the major guiding principle in our consultation paper. And we have made reference to the practices of other jurisdictions. And it's included in our consultation paper as well. And that is, we propose to follow the English law as our starting point, but we will not follow 100% of the UK Act. Now, some major recommendations on the offence of rape. There is a very fundamental concept of consent. And our recommendation is that there should be a clear statutory definition of consent rather than relying on the common law cases. And that is, there is a need for free and voluntary agreement to the sexual activity and the capacity to consent. On the newly defined offence of rape, there should not be any distinction of the sex or gender of the victim, such that either sex can be a victim. And also, the recommendation covers penile penetration of the vagina, anus, or mouth. And that is sexual intercourse, vaginal intercourse, anal intercourse, or oral sex will be covered. One other recommendation is that will be departing from the principles derived from common law cases, and that is, at present, if the defendant holds a genuine and subjective belief that the complainant consented, the accused is entitled to be acquitted, even if the belief was unreasonable, and we feel that this might not promote sexual autonomy. So we're suggesting that the mixed test of subjectivity and objectivity be adopted, and that is, there should be a sense of reasonableness. The offender should hold a reasonable belief that the complainant has consented, and it depends on what reasonable steps the defendant has taken to establish this belief. Now, only when the belief was unreasonable and the evidence is able to establish that can the offender be convicted. The other recommendation is that we propose to introduce a new offense, and that is sexual assault by penetration. At present, we have a serious offense of rape and to a lesser degree, indecent assault. For some sexual offenses, it may not involve the penis of a male, but the degree of assault on the victim is very serious, to the extent that it is hardly distinguishable from rape, and we think that a new offense of sexual assault by penetration should be created, and the maximum penalty will be equivalent to that for rape. The other recommendation is that the indecent assault at present will be substituted by a new offense of sexual assault. In practice, there will not be many differences, but when it comes to indecent assault, there is an element of morality and whether the act is indecent or not. But we think that the focus should be on whether the assault is sexual in nature. So we propose that the offense of indecent assault be substituted with sexual assault. Now, as for underskirt photography, this is also a focus of the media's attention. Our proposal is that there is no need to create an offense for underskirt photography, but we need to define what constitutes sexual offense, and we think that physical contact may not be necessary. Even without physical contact, you may be infringing upon the sexual autonomy of an individual. That is to say, if the photography or the photographs are taken, which is sexual in nature, it may constitute sexual assault. That is, if the act, when known to the other party, might cause the person to feel degraded or harmed, then such act may constitute a sexual assault, but we'd like to seek views from the public on this point. Now, the other recommendation is that the offense of procuring another to do an unlawful sexual act for the use of threats or intimidation will be abolished. Instead, we'll create an offense of causing a person to engage in sexual activity without consent. And that is, it will be easier to prove. You may not be threatening or intimidating another person to engage in a sexual act, but as long as the person does not consent to the sexual offense, to the sexual activity, you will be committing this offense. Now, just a few more words on our work. We issued a series of consultation papers before, including the Sexual Offenders Register, and this has been implemented already. And there is also a LRC report on the presumption that the boy under the age of 14 is not capable of committing a sexual offense. And there will be other consultation papers coming, and I'll be happy to hear views from members before we decide on our way forward. Thank you, Mr. Eric Zhang. Let me invite the representatives of the two legal bodies. First, Mr. Andrew Bruce from Hong Kong Bar Association.
Very much for inviting me to speak on this. The Bar Association has not yet formulated a formal response to this, but there is a lot in this report which I have no doubt would be supported, and strongly so. The guiding principles that have been referred to, clarity of law, respect for sexual autonomy, and so on, seem to me to be non-negotiable, and I'd be astounded if the Bar didn't support those. Clarity of the law is a standard that we would hold the rest of these proposals to, because there is always a danger when you change things that you change well understood laws, and you have to ask yourself, when we redraft something, even though it might sound nice when you do it, whether it's really going to achieve its object. And for the most part, that warning will be no doubt taken into account by the administration should they take this very thoughtful paper up. But there are dangers aplenty if we don't carefully scrutinise, and I'm speaking generally, of the exact words, because clarity of the law and precision in this highly emotive area is going to be a very big challenge for anyone. Others have tried it and mostly succeeded. The other component that may cause concern is the issue of the state of mind that is required to be proved when an accused is charged with rape, even the extended form of rape that we're talking about at the moment. At present, it is true that theoretically a person could be found not guilty if the jury are not sure that he had a genuine but mistaken but possibly unreasonable belief. But how does that work in practice? I've prosecuted cases, I've defended these kinds of cases, and I can tell you that the simple truth of the matter is that reasonableness is at the forefront of the jury's analysis of this. The idea that you could go in there with some way out idea and say, well, most people wouldn't think this reasonable, but I did, is just not going to happen in the real world. There's lots of interesting academic discussions of this, and academics get themselves in all sorts of tangles about this, but if you go into a real court prosecuting real people with real witnesses and a real jury, I ask you to question carefully this nice sounding proposal where, we'll just bring reasonableness into this. But again, the key challenge here would be how you phrase the legislation, because we made this mistake with other offences of bringing a notion of reasonableness into this in the statute. And the best example of that is money laundering, where you can be guilty of money laundering even though you don't know anything bad about the money that you handle, as long as a reasonable person would think that. And so I'm not saying we shouldn't do this, but I venture to suggest that we have to think very carefully about the precise phrasing. Now, as I say, you go back to the basic problem. This is about sexual autonomy, and that is overloaded with values and morality and so on. So sometimes precision of language, whatever language, is going to be a huge challenge. As to the rest, my instinct is the bar will come down very strongly with possibly positive suggestions. We have no other kind of suggestion. Positive suggestions. The upskirt photography issue, I'm grateful that the Law Reform Commission has grappled with this, because as a practitioner, I've had clients who are charged with this, and at the moment they use the charge of disorderly behaviour. And it seems to me that when they drafted that offence, the idea that they had upskirt photography in mind as part of the conduct there, it seems to stretch the logic of that beyond breaking point. I think the bar will probably come down strongly on the side of, let's get real about this, let's get a clear piece of legislation which penalises this and penalises it clearly, and so that nobody is in any doubt that this is part of the standards of Hong Kong. I hope those comments are helpful, Chairman. That's all I have to say at this stage.
好，多謝Mr. Andrew Bruce。
Thank you, Mr. Andrew Bruce. Next, I'll invite Mr. Stephen Hong from the Law Society to speak. Thank you, Madam Chairman. On most of the recommendations in the consultation document, the Law Society agrees. I just want to raise 2 points. When we discussed the consultation document, we had a number of concerns. One of my clients sought legal advice from me in relation to his son, who's dating a slightly mentally retarded girl. They met each other in a center, and then they would like to go on a trip, and the parents were concerned because many youngsters had sexual relationship when they're on trips. So my client asked me whether that should be possible. I said, I really don't know how to answer this question. Well, medically, if it is a mentally retarded, then his son has to make sure that he is not luring her or cheating her. And then he asked her whether he could seek advice from the girl's parents. I said probably not, because in law there's no provision for seeking advice from the girl's parents. And at present, under our laws, the prosecution has to prove that the behavior does take place. And in this case that I just cited, the boy may be hurt. And then the other issue is about rape. We do not oppose to gender neutrality. That is, if some other objects are used for entrance, we're not saying that that sort of behavior is not serious, but the definition for rape has been in place for so many years. For a general member of the public, he or she has his own concept about rape. For offenses committed by mouth, that is forcible oral sex. If the incident only involves violent or forcible oral sex, that may not constitute a reason for conviction, because for the general public, they may think that rape is really a serious offense. I'm not saying that we should condone the defendant just because of the name of the offense. Say in manslaughter cases, the court has always been unwilling to pass a judgment on manslaughter or murder, because if you pass a judgment, a conviction on murder, you'll actually be sentencing the person to capital punishment. So I think we need to legislate on the new proposals separately. Thank you, Mr. Hong. I would now invite members to speak. Those members who are interested, please raise their hands. I'll read out your name. Dr. Fernando Chang, Mr. Albert Ho, Mr. Dennis Kwok, Ms. Chang Lai Wen. I think I saw another hand. Alice Mack. So 3 minutes each. Dr. Fernando Chang. Thank you, Madam Chairman. Sex offense is a serious offense. Very often, the victim is not just affected at the time of the offense, but throughout his or her life. So this review is very important, and I welcome the LRC's recommendations on legislative amendments. Well, the legislation has been in place for 50 years with no amendment. So overall speaking, we support the recommendations. In reality, some associations still have comments. For example, some women groups are of the view that rape and penetrative offenses are very serious, even if it is penetration with other devices. And then there's this protection of identity, because if the victim is to disclose his or her past sex experience, that will create another form of harm on the victim. And some homosexual organizations would like to see further amendments in terms of definition. Therefore, Chairman, I suggest that this panel should call a public hearing so that all those who are interested in this piece of legislation can express their views. We know that this consultation will last till the end of this month, but this document was only submitted to us in September. With just 2 to 3 months' time, it's rather difficult to a lot of organizations and associations, because the content of the document is not easy to assimilate. I suggest that the consultation period be extended for, say, 2 to 3 months, so that we can pass our views to the administration. Next, Mr. Albert Ho. Chairman, I believe nobody will disagree to the proposal that sex offenses should be prohibited through a number of measures. If we are to expand the definition of certain serious offences and the applicability of the definitions, we have to be very careful. We're talking about two rights. One right is to guard against such offences and to protect the right of the possible victims. Secondly, should we use very harsh laws to resolve the problem? The problem facing us is, as time goes by, as social circumstances change, for example, nowadays people become mature quicker, then we would like to change our laws to tie in with the lowering of the age of sexual capability. Now, if you say that a particular act may lead to certain consequences, we'll say if we're talking about treatment for deceiving acts, well, in fact, such deceiving acts have always been in society ever since ancient times. So I think we have to be very careful if we want to change definitions. I myself have to deliberate very carefully on this. I'm not saying that we should not create new offences to guard against certain possibilities and to protect potential victims. Rape will affect life imprisonment. So should we do it by way of changing the definition of rape? And then there's sexual assault, like under the skirt photography. Well, I'm also a bit worried. Should under the skirt photography become a sexual offense? Where should we draw the line? I don't have the answer today, but we have to be very careful. I'll ask the RRC representatives to answer members' questions in one go in a moment. Next, Mr. Dennis Kwok. Madam Chairman, I'll be brief because we're under time constraints. I'd like to thank the RRC members for spending so much time to prepare this document. I'd also like to thank the Law Society for their presentation. If possible, I'd also like to have a paper, a written submission from the Bar Association to state clearly their position. Just now, the legal profession said that we should be very careful in studying the details in relation to legislative amendments. In particular, we're talking about major amendments in this exercise. So I agree that the consultation period should be extended to ensure that the statutory provisions, as Mr. Bruce said just now, are clear and exact. Those are two fundamental principles. So in future, when we draft the amendments, the administration should take on board the views of the Bar and the Law Society. LRC representatives, would you please respond to members' views, in particular to the request for an extension of the consultation period? My understanding is that for the operation of the LRC, if members of the public deem it necessary to extend the consultation period, we'll be happy to do so. I'll take this request back for a decision. And we can listen to the views of the deputations as well, and we're happy to do that. Sometimes when we try to strike a balance, we're criticized by the public that we're acting too slowly. But basically, there's no problem to extend the consultation period.
Just to briefly respond to some of the points raised by members, for example, Mr. Albert Hall said that we should not enact draconian laws, but this is not our basis. Well, according to our guiding principles in the papers, these are the principles that we base on. It's not a case of whether we make harsh laws or not. As for the other point, whether deceptive or obtaining consent for sexual activity by deception will amount to rape, well, in fact, this is not our recommendation. Our recommendation is to retain the existing common law practice, and that is the consent should be consistent with the nature and objective of the act. That is, for example, in a case where allegedly the sex is for treatment. Now, for example, if you conduct a medical examination on the victim for which is sexual in nature, which is deceptive, then under the existing common law practice, this is non-consensual. Now, whereas for other sexual offenses, for example, allegedly if there is a sexual intercourse, you can change your fortune, then it's not a matter of consent or not, but then it is a form of deception, and there is an offense for that, and this will be retained. I don't know whether I should respond to the views of the two legal bodies first, or we still have time. Let other members speak first. Ms. Ann Chang. Thank you, Madam Chair. We welcome the consultation paper of the LRC on rape and other non-consensual sexual offences. They've put forward a number of recommendations. Now, in particular, Chapter 5, we think that is quite good. So, okay, if there is penetration with whatever object, and if the act is sexual in nature, it will be regarded as a penetrative assault. Now, but we're a bit concerned about Chapter 6. Under the skirt photography, for example, or voyeuristic photo shooting. Well, under the skirt photography is not good, of course. But at present, the offenders are charged with offenses like outrageous public morality or disorderly conduct. Now, if the offense is one of sexual assault, as per your recommendation 20, we're concerned that whether some youngsters, some teenagers during puberty may engage themselves in such acts out of curiosity, so on and so forth, and without adequate public awareness and education, they might be inadvertently caught by the law, so we need to be careful about it. I'll invite the LRC to give a consolidated reply in a moment. Ms. Alice Mack. Now, one point in response. That is, the LRC is not proposing to create an offense or create a new offense of procuring a sexual act by the use of threats or intimidation. Well, this is the concern of women's groups, because the concerned group wants to get better protection for women through this redrafting of the laws concerned. Now, even if threats or intimidation is not used, it might still harm the female victim. So we think that more protection should be offered to women. And I'd like to go back to the point about under the skirt photography. Of course, we understand that some may ask if the punishment is too harsh. But we see that there is a prevailing trend of such act in the society, and relatively there is little protection for women. We think that the law should offer greater protection for women. Well, as said in the paper, it depends on whether the act would cause fear, degradation, or harm to the victim. If the person taking the photo has the intention of causing harm or fear or degradation of the female victim, then we should consider the severity of the offense. Any other views? I'd like to offer my views as well. In particular, the written submission of the concerned group Rain Lily. Now, in relation to this paper, they have also prepared many recommendations, and I hope the LRC would consider these as well. For example, on how to minimize the bias of the jury, and also recommendations 7, 8, 10, 11, in particular in 14. Procurement of sexual acts may not be done with the use of threat or intimidation, but with economic coercion or with naked photos or nude photos, and these should also be taken into account. And there is also a recommendation that the Hong Kong law should follow the English and Scottish acts in adducing evidence and in the relevant procedures. So, may I invite Mr. Eric Zhang of the LRC to respond to our points? And then we can move on with our discussion. As I gather, they also agree that we can arrange for a public meeting and that the consultation period can be extended. Mr. Zhang. I want to reiterate that as a member of the subcommittee, this is a genuine consultation. So we're happy to take as many views as possible so that these views can be incorporated in our discussion. We really want to hear as many views as possible. But perhaps I should clarify on a number of issues concerning our recommendations. Now, Dr. Ann Chang made a point about under the skirt photography. She asked whether there could be a problem with publicity or education. Now, at present, under the skirt photography, does not constitute an indecent assault offense. At most, the offenders will be charged with offenses like dishonest use of computers or outrageous public morality or the disorderly conduct, etc. Now, for some, under the skirt photography, it's an act that allows one to satisfy one's sexual imagination or fantasies. But for some other acts, for example, those photographers may take pictures of celebrities simply for the purpose of infringing on the privacy of such celebrities, and their act may not be sexual in nature. And that's why we recommend that the act should be sexual in nature. And if there is sufficient evidence that under the skirt photography has been done, and that is the act is sexual in nature, we'd like to hear the views of the public as to whether these should amount to sexual assault offences. Now, some women concerned groups hopes that there could be greater protection for women. Of course, we understand this point, but our consideration is not just about women, because our principle is gender neutrality, and men should also be protected as well. So we consider whether the existing law offers adequate protection of an individual's sexual autonomy. This is our primary consideration. In fact, we did explain our position to the women's groups and organizations. We exchanged views already. Now, on the burden of proof and on whether we would adopt the English and Scottish Acts, and there is whether there should be any rebuttable presumptions, all these points were considered when we prepared the report. But we're happy to seek more views. Now, for the English legislation, yes, there are two parts, and there is a part about rebuttable presumption. For example, for consent, if you procure consent to sex with an allegation that it's for the purpose of treatment, then this is not about consent. Now, when we look at the English law, when we looked through the records, they did not propose to adopt that as well. It's a very complicated concept. The whole concept is not about changing the burden of proof. Only the evidential burden is changed. That is, when there is a live issue to raise a doubt, the prosecution has the burden to rebut that beyond reasonable doubt. So for the English law, they did not adopt it because there would be a greater chance of error. The jury might not understand it either. So if there is a rebuttable presumption that the person does not consent, etc., well, I think that if I use all these jargons, people here might not understand either. So our proposal is that we should not make things complicated. Representatives from the two legal bodies, anything to add to members' views? I hope the consultation period can be extended. If I remember correctly, we have waited for more than a decade for this reform to take place. I think we might as well wait a bit longer. Nothing to add further, Madam Chair. I'm sorry, we've drawn a line. If there's nothing to add from members, then perhaps we should discuss the arrangement for the consultation period to be extended. Some member just now suggested that it be extended by 2 months. So let me hear from members. Anyone objecting to the arrangement of a public hearing within the consultation period as far as practicable? No objection? All right, so we will arrange for a public hearing. Now, there is already an available time slot, and that's 2:30 to 4:30 on the 8th of January. I hope more members can attend this public hearing. So this is tentatively the time slot for public hearing, and the Secretariat will confirm with members in due course. So, thank you, representatives of the LRC and the two legal professional bodies for attending. Now, during the public hearing, we will be hearing more views, and members also have the opportunity to express views then. We think that a more in-depth discussion should be held. Madam Chair, may I spend 2 minutes to respond to the Law Society's comments? In relation to the 2 points raised by Mr. Hong of the Law Society, I'd like to respond to their views as well. On this example of dating a mentally disabled person, what should happen? Now, in our report on the definition of consent, it's very clear. It depends on the capacity, whether the person has the capacity to give consent. So it depends on the mental capacity or the mental condition of the person, whether he's capable or he or she is capable of giving a consent. If the mental incapacity is such that the person is unable to give a consent and the person has no idea of how to give a consent, then the consent would not be valid. Now, for the slightly mentally handicapped, he or she may be able to give consent, and we also need to protect the sexual autonomy of such individuals. So in our next consultation paper, we will explore the issue of drawing a line on the age limit on mental capacity.
Point number 2, what about violent oral sex? Should that be considered as rape as well? Should there be a conviction for such an act? I think we have to consult the public. At present, the definition of rape is confined to the penis of a male. That is penetrating offense. But as some women concerned groups say, even if you use other objects to penetrate the vagina of a female, it's also very serious. So that sort of act should also be considered as rape. That's why we propose to change the definition of rape. But for violent oral sex, some women groups actually told us that that should be taken as equivalent to rape as well. Well, I'm not a legislator. I don't know the views of the public. You're the legislators. You should consult the public on whether or not we should change the definition of rape as proposed. Sorry, I've already drawn a line. We still have 2 outstanding items for discussion today. We'll just now, point 20 of the submission from the Association concerning sexual violence against women is related to under-the-skirt photography. And they say that the sentiments of the victim should also be considered. So please go back and consider that. Now, there will be a public hearing on the 8th of January. Well, yes, I understand that some of you have raised your hand, but sorry, we don't have time anymore today for this item. So let's listen to the public on the 8th of January first. So thank you very much, representatives from the LRC and the Bar Association and the Law Society. Thank you very much for presenting your views on the consultation document. We'll proceed immediately to the next item on the agenda. Information Technology Infrastructure for West Kowloon Law Courts Building. In the new West Kowloon Law Courts Building, the IT infrastructure, digital recording systems and other services have been implemented. It's envisaged that an additional cost of $51.79 million will be required, and they are prepared to go to the FC to seek funding. I'll invite the judiciary to present their paper to us. Is it Ms. Lau? Yes, Ms. Lau, please. Thank you, Madam Chairman. First of all, we would like to thank the LegCo for its support, because on the 1st of April, over $270 million had been allocated to the judiciary for the construction of a new West Kowloon Law Courts building. The project was upgraded to Cat A. Works have already commenced. For this West Kowloon Law Courts building is in Tung Chau Street and Tonkin Street West Junction in Sham Shui Po. There will be 32 courtrooms and other essential ancillary facilities for the courts. The magistracies, the Small Claims Tribunal, the Coroner's Court, and the Obscene Articles Tribunal will be contained in the building, which will be completed in 2014, and then we'll do retrofitting. When everything is completed, during the latter half of 2016, we believe the building could be commissioned. In order to provide the essential IT infrastructure and digital audio recording and transcription services system to the building, earlier this year in February, we applied to the Finance Committee for fund allocation. We would like to have over $51 million for the essential computer systems. And the proposals in the paper mainly cover certain major items. That is, to provide IT infrastructure to the court building such that all judges and staff in the building can use computers to support their work, including case management system. Secondly, in the building, we'll provide sufficient space for a server center to suit the existing and future need of the judiciary. And then for the 32 courtrooms, we'll provide a digital audio recording and transcription service system. This was actually introduced in 1996 in all tiers of courts, and at present is already an essential part of our courts and court operations. So these are our proposals. My colleagues and I will be more than happy to answer members' questions. Mr. Tan Yu Chung and Ms. Emily Lau, as well as Mr. Albert Ho, have signified their wish to speak, and also Mr. Charles Mock. 3 minutes each, please. Mr. Tan Yu Chung. Thank you, Madam Chairman. In society, there's been dissatisfaction in relation to public requests for English and Chinese recordings and transcript fees. For those who do not have legal aid, that's a heavy burden. And all along, the judiciary told us that it formulated its fees and charges on the basis of cost recovery. So for this new digital audio recording and transcription service system, you should try to reduce cost as far as possible. For the newly procured equipment, will you pass the cost on to court users? Because you're talking about tens of millions of dollars. Well, the existing fees and charges are already too high. So with all these new equipment, will the fees and charges be further increased? Any information for us? Ms. Lau? Thank you, Chairman. Thank you, Mr. Tam, for our recording and transcription service. The fees and charges are formulated on the basis of cost recovery. That is, our contractors' fee as well as administrative fees. So if you move to the new building, will the fees and charges be even higher? Will you maintain the fees and charges at their present levels? So, any plan to increase the fees and charges? Ms. Lau? Concerning these fees and charges, last time when we came to this panel, it should be 2010. Back then, we discussed the issue. At that time, we proposed that for both the English and Chinese transcripts, irrespective of the number of words, the fee level should be maintained. And even now, we have no intention to increase the fees and charges. So the present level was actually formulated a few years ago. Next, Ms. Emily Lau. Chairman, for many years, I've offered support to the administration in the use of IT equipment, which would facilitate judges, lawyers, and other members of the public, because such systems will help all parties concerned to retrieve information more efficiently and effectively. Now, for this new system, Chairman, I raised before that I would like to have immediate production of transcripts. Now, I recently went to the United Nations to attend a conference on the handicap. And you see, as the conference proceeded, they had a screen that showed the proceedings. Back then, the administration told me that the equipment would be very expensive. Are these equipment really very expensive? Are we going to leave all these to the parties to the litigation? If they want such equipment, let them do it. Can we have all the proceedings shown? And did anybody ask you to introduce such equipment? Ms. Lau? Chairman, I think Ms. Lau was referring to an immediate transcription system. Actually, in some of our courts, with court consent, immediate transcription service is provided with consent from all parties. But usually, such an immediate transcription system is rather complicated and is usually used in longer and complicated cases. The system or the service is not used in all cases. But if necessary, with court consent, the service can be used. In fact, this sort of immediate service has already been provided for certain cases. Ms. Lau also asked about the judiciary's IT plan for the future. Now, this paper is particularly about the essential IT infrastructure for West Kowloon Law Court's building, and we're seeking funding support from members. In the past, the judiciary actively and positively reviewed the IT plans for the whole judiciary, because IT is ever advancing and advancing very rapidly as well. So we should use IT to assist our courts and judges such that court users will find our systems more convenient. In February next year, we will come to this panel again to present you with a more comprehensive development strategy. Then I can give you more details. Can I have a minute more? Now, for this transcription service system, do you need to introduce some additional devices such that you can provide immediate transcription service, or in future, whoever is willing to pay can get the service? We've already got the infrastructure at the moment. So in future, if immediate transcription is to be provided, we can do it. Well, Ms. Lau mentioned her experience overseas for this conference on the handicap. I think the advice was very useful. Mr. Abuto? Well, if you go to Taiwan, you see that all their courts provide transcripts immediately. In front of every lawyer and witness, there is a screen, a monitor to immediately show the proceedings.
Say for a trial, there may be 30 days of witness testifying. And sometimes if one party is represented but not the other party, the judge may find its job very difficult. Well, you may need to refer back to 30 days of audio recording. So I think that we should pay a visit. Well, we're only talking about courtrooms at present, but I understand that this is about another thing, and whether immediate transcript can be made available. Perhaps the judiciary administrator can pay a visit together with some judges. And I also heard that some courts in the mainland also have court stenography services, and it's very important. The second point, in major cases, well, for court one, it may be a bigger court, but for some other side courts, it may be smaller courts. So I am thinking whether you would consider having a room that accommodates all the equipments. And that is, if the courtroom cannot accommodate the public in a major trial, there would be a room, a viewer's room, so that we have a true open public hearing. Thank you, Mr. Ho, for your question. In fact, in designing the West Kowloon Law Courts building, consideration has been given to the need to cater for different types of cases. So one of the courtrooms in the WKLCB will be a big courtroom which can accommodate 100 people in the public gallery. As for smaller courts, it's of a comparable size to ordinary courtrooms. So for WKLCB, we already have the design for a large courtroom and some smaller courtrooms. And these courtrooms are equipped with LCD screens so that video transmission can be made possible. I'm sorry, very short follow-up question. Now, I don't suppose you understand this. For a big case, the public gallery does not have sufficient seats. I mean, even for the bar table, there aren't enough seats for counsel. So there should be another place for the public's viewing. Yes, Mr. Ho, we do have this facility. I am just explaining to you that we have courtrooms of different scale and sizes. All right, Mr. Charles Mock. Madam Chair, I think transcribing is useful. Because there might be different dialects of the Chinese language. So the most efficient way to do it is to provide multi-language transcription. But of course, it will be costly because we need professionals to provide simultaneous translation. Now, just a question on information technology. For this new court building, how is the IT design different from existing court buildings? Has there been any improvement? As for establishment, are there any permanent posts, or how many of them are contract staff or outsourced staff? Thank you, Mr. Mok, for your question. On immediate transcription service, as I understand, from our experience, it's most widely used in English trials. Now, our proposal is about IT infrastructure. One of our proposals is that a larger server room can be built to accommodate the servers. Because we do not at present have sufficient room to accommodate the new computers and equipment. And in order to provide sustainable services, we think that we should have 2 server centers. So this new WKLCB server center, in February, we will be submitting a more detailed paper on the strategic IT infrastructure plan for the judiciary in the future, and that is sufficient room and equipment will be provided. And on the establishment and the future arrangements, I also hope that in February, when we explain our strategic plan, we'll be able to give you more details. Madam Chair, I just want to follow up on one point. This is exactly because of the language issue. If it's English speaking, if immediate transcript is available, then people can read the transcript instead of relying on the simultaneous interpretation service. And at different panels and different committees of the LegCo, I always pop up this question. That is, why don't you use the centralized server center or the cloud computing service provided by the government? Well, I don't know what is the reason behind. Perhaps you think that you should have an independent server center. But the point is the government information service has its own server center. So in February, you should give us a reply on whether you have considered using the centralized service center, and what is the reason for not using the centralized service. Ms. Emily Lau. Well, I hope that the legal sector and the IT sector will be consulted so that their views can be incorporated in your paper. As for immediate transcription service, Mr. Albert Ho was talking about the service already available in Taiwan and mainland courts. And we're actually lagging behind. We should go back and think about it and see how much money are we talking about, and see whether this can be supplemented in the paper to be submitted to the FC, and see if this service can be made available in this new court building or even other court buildings. I asked Ms. Lau whether any requests have been received from judges and lawyers for the provision of these facilities, but she hasn't answered. Thank you, Ms. Lau, for your question. As I explained, on the request of the parties of litigation in the High Court, with the leave of the court, immediate transcription service is already available, and the costs are to be shared by the parties. Well, Madam Chair, I'm saying that this should be made a regular practice, and the cost should not be borne by parties. But this is a policy issue, and I will take members' views back and consult a committee of the judiciary chaired by judges. Now, members have expressed concerns about the modernization of IT technology, and the reference should be drawn from courts in other jurisdictions. Now, our position is very clear. For the benefit of the public, you can come up with more IT measures and come back and report to us. And in particular, in relation to modern IT facilities, you can come back and report to us, because we really need to catch up with other jurisdictions. I understand that this is about policy and discussion is required, but I hope that they can include this part in their paper, what considerations have been given, and if they decide not to go ahead with it, they should tell us why. In 2013, in February, there will be an item for discussion. That is implementation of the IT infrastructure and IT policy of the judiciary. And this will be an appropriate time for you to respond to members' concerns. So let's wrap up this item. We are going to move on to the other item. So thank you, Jay, for coming. The final item, proposed amendments to the arbitration ordinance CAP 609. LC paper number CB bracket 4228/2012 bracket 04, and that's the administration's paper. CB bracket 4228/1213 bracket 04, as well as CB bracket 4242/2012 bracket 02. Now, we are scheduled to end at 12:45, but I have the discretion to extend the meeting until 1 o'clock so that we have a reasonable time for discussion of this item. Now, on the reciprocal recognition and enforcement of arbitral awards between Hong Kong and Macau, the administration is proposing to amend CAP 609, and with members' support, the administration proposes to submit this amendment early next year. So, Mr. Peter Wong from the administration, please take us through the paper. Thank you. Madam Chair, we're here to brief members on the administration's proposal to amend the arbitration ordinance CAP 609, and there are two parts in our paper. Now, after implementing the reciprocal recognition and enforcement of arbitral awards between Hong Kong and Macau, this arrangement will come into effect, and Paras 20 to 25 sets out the relevant amendments to be made. And last year, at the meeting held on the 28th of February, the administration consulted the panel on the proposed arrangement, and at that time, we proposed that the terms of the arrangement would be similar to the existing arrangement between Hong Kong and the mainland on the mutual enforcement of arbitral awards, and the principles of the New York Convention would be relied on, and the following paragraphs briefed members on the consultation work by the administration with positive response. Basically, the respondents have shown positive response to our proposal. And in April, After initial exchange of views and comments, in June 2011, we had further discussions with the Macau authorities. And we hope that the final version of the arrangements will be ready for signing. And for implementation of the arrangement, amendments to the arbitration ordinance is necessary. And in paragraph 12, we set out the proposed amendments, and that is a new Division 4 will be added to Part 10 of Cap 609 concerning matters relating to the enforcement of Macau arbitral awards under the arrangement, and also partially satisfied awards, and also so on and so forth. Now, in para 13, all the way to para 19, we set out the details of the arrangement.
The content was actually based on the arrangements in Macau and the mainland, as well as the New York Convention. From paragraphs 15 to 17, we explained our policy direction. Applications can be lodged concurrently, provided that the total amount recovered from enforcing the award in courts of the two places shall not exceed the amount awarded. We've actually referred to views received during the consultation exercise before proposing this arrangement. Macau has no opposition to this proposal. In paragraph 19, we particularly emphasize the enforcement of Macau awards. We would like to comply with the grounds under the New York Convention. This will also cover void arrangements or void judgment. And then starting from paragraph 20, we mentioned something about emergency arbitrator. Before an arbitration is established, if the parties concerned would like to have interim measures, then by way of this emergency arbitrator, arrangements can be made. At this stage, we are still discussing with the Hong Kong International Arbitration Center to work out the details. The other two aspects of amendment are related to taxation of costs of arbitral proceedings. And together with the International Arbitration Center, we'll make some revisions. The costs shall be taxed by the court on a party-and-party basis, which is set out in paragraph 23. In paragraph 24, we say that in recent years, there were new signatories to the New York Convention. So the three jurisdictions, including Fiji, as mentioned in paragraph 24, will be included to enforce the New York Convention. We also say therein that as a result, the rules of High Court will have to be amended as well. That's in paragraph 25. Chairman, we're now actively drafting the bill in the hope that we can have a final draft as soon as possible. We would like to introduce the bill into LegCo in the first quarter of 2013. Anyway, our objective is to introduce the bill into LegCo for discussion and enactment within this session. Thank you. The Bar Association has sent in a submission. So please refer to paper 242-02. We have Mr. Robert Pang from the Bar. Thank you, Chairman. Basically, the Bar supports the administration's proposals. We hope that they can implement the proposals as soon as possible. All right, members. First, Mr. Dennis Kwok.
Coming from the direction of the Hong Kong International Arbitration Center. As you know, the representatives of the HKIAC cannot attend the meeting today. So if I may simply direct those comments to you, Mr. Wong. Those are, as you know, the HKIAC are in support of the proposal put forward by the administration. But the comments they have are in relation to first, number one, whether there are measures to streamline the enforcement section in the arbitration ordinance to make it more simple and user-friendly. If you can, just make a brief reply to that. Number two, it is in regards to the emergency arbitrator issue. As you know, the Hong Kong IAC have just revised their administered arbitration rules, and those rules will take effect in March 2013. Would it be possible to consider some amendments, introducing some amendments to give legislative underpinning for the appointment of an emergency arbitrator appointed pursuant to the arbitration rules, and whether the administration is open to that sort of suggestion? Thank you, Chair.
係，請阿黃生。
多謝主席。就各議員提出。
Mr. Kwok mentioned enhancement of arrangements. Chairman, as I said just now, our thinking now is to resort to Part 10 of Chapter 609 and to add in 2 new divisions, maybe Division 2 or Division 3, to introduce the new arrangements. Well, users will be able to see a similar pattern in the mainland. So that's part 1 of the question. Part 2 of the question about the emergency arbitrator. We are actively discussing with the International Arbitration Center to work out the details. Well, basically there are 2 areas. First of all, when we amend the ordinance itself, how many details should be included in the bill, the amendment bill? Will there be framework provisions, for example, to introduce the definition of emergency arbitrator and its functions and so forth? That would be simpler. Secondly, whether enforcement can be done at the same time. The Arbitration Center would like the administration to match their new emergency arbitrator rule. So we would like to match their effort as well. So 2 areas. First of all, how many details should be included? And secondly, the pegging issue. At the same time, we must not conflict with the existing ordinance, which was enacted in 2011. So the foundation of this ordinance is sound. So we're actively in discussion with the International Arbitration Center. I would also like to offer some supplementary views and would like to have some response from the DOJ. Now, the International Arbitration Center was set up in 1999. And then in 1998, the mainland and Taiwan established a reciprocal recognition arrangement. Now, in paragraph 23, you mentioned public policies and procedural justice. For Macau and Hong Kong and mutual recognition of arbitral rulings, I would like to see whether or not you have concerned any conflict with the public policies of the jurisdiction concerned, whether you have a saving clause on this. Now, what about after reciprocal recognition of arbitral rulings? Any concrete arrangements? Can we have some reference information? Chairman, well, as far as I understand from your questions, you would like to see how we handle public policies, right? Chairman, was that your question? Well, we'll adopt a major direction here. The concept of recognition of public policies will be invoked in interpreting the arbitral rulings in Macau and Hong Kong, so as not to affect the enforcement of arbitral rulings. And this is in line with international practice. Well, Chairman, you also mentioned reciprocal enforcement of arbitral rulings on the mainland. I don't have the details here, but in general, the arrangement has been implemented very smoothly. The paper quotes an older figure. In December 2010, statistics indicated that enforcement had been smooth. Of course, in the course of enforcement, if there are concrete problems, we can resolve them by way of communication. So we'll be able to enforce arbitral rulings. And on both sides, every now and then, we have judgments to enforce arbitral rulings on either side. So operations have been smooth. After completing Macau, we'll proceed to Taiwan. And what will be our next step? We're actively negotiating with Taiwan to explore the possibility of reciprocal recognition of arbitral rulings. But we're still in a stage of exploration. And with the mainland, we also have unofficial avenues for exchanges. I can only say that we are actively pursuing the issue, and we do have two unofficial avenues for the pursuit of this issue with mainland and Taiwan. Well, in 1992 and 1998, the mainland and Taiwan had established mechanisms for reciprocal recognition of arbitral rulings for both sides. I also have the impression that you gave us a paper in 2010. So if possible, please give us an updated paper on the enforcement figures and circumstances for reciprocal recognition of arbitral rulings. So if there are no further comments, we've completed our discussion items. Meeting adjourned. Once again, our next meeting will be held on the 8th of January, which will be a public hearing. Thank you.